Good afternoon, everyone. I am Mildred Kahukom, and this afternoon we are going to discuss the Chapter 6, which is the moral rights in the workplace. So, I believe that as a student under business administration, we already have the knowledge about the significant rights that each employees have. So, it's not the first time, I guess, to learn that moral rights in the workplace exists. However, to give you a more concise wisdom, this discussion will help you to broaden your perspectives and to understand more how these moral rights works and how it applies in the workplace. So, at the end of this discussion, students are expected to know the different employee rights, and that includes the right to work, employment at will, due process in the workplace, participation rights, freedom of expression, employee health and safety, and lastly is the privacy in the workplace. To begin with, there are 3 employee rights which are very common in every business. First is the legal rights. So, legal rights is granted to employees on the basis of legislation or juridical ruling. Say, for instance, every employee has the right to a minimum wage, equal opportunity, to be part of a union, and, of course, a workplace that is free from danger, discrimination, or even sexual harassment. So, those are legal rights. Second is the contractual rights. So, it is the basis of agreement with employers. In a sense of contractual right, a particular employee might have a right to a specific healthcare package, or a paid holidays, pension funds, and other incentives as part of their employment contract or contract of law. So that is contractual rights. And lastly is the human rights, or the respect owed to employees as human beings. Take note, human rights is important to be emphasized in every aspect, and even in business. Okay? Because it is needed to protect and preserve every individual's humanity, to ensure that every individual can live a life of dignity and a life that is worthy of a human being. Therefore, it is important to note that every employee are entitled to these rights in order to protect them from certain harms that might possibly occur within the workplace. And of course, through these moral rights, it established the basic ethical framework for employee-employer relations or employee-employer relationship. So next is the right to work. So in many contemporary political and legal contexts, the right to work refers to a right to work without being required to join a local union. Why? Because this requirement is seen as an essential means to protect the viability of a union and the entire collective bargaining system. However, several states have passed legislations that prohibit such a requirement, and that legislation is called the Right to Work Law. When we say the right to work law, it gives the workers the freedom to choose whether or not to join a labor union in the workplace. This means employees are not forced to make unwanted decisions. This also makes it optional for employees in unionized workplaces to pay for union dues or other membership fees required for union representation, whether they are in the union or not. Actually, the right to work created couples of arguments, as some believe that work is a primary means to such ends as food, clothing, shelter, and healthcare, and that each individual has a right to work. However, please take note that the right to work is not just simply means right to a job, but in overall, it is a responsibility to hold that job with some degree of security and making sure not to be fired from that job without just and sufficient causes. Next, for the next topic, it would be continued by my group mates. Thank you.
Employment at will means that employees are free to quit their job at any time for any reason, and employers are free to terminate an employee at any time and for any reason. In the words of an early court decision establishing this precedent, all may dismiss their employees at will, be they many or few, for good cause, for no cause, or even for a cause morally wrong. If employment at will governs the workplace, if employees can be dismissed for morally wrong reason without violating the law, then the concept of employee rights is, at least in the legal sense, meaningless. An employee right would be a legitimate claim to certain goods or to protect against certain harms in the workplace. To say that employees have a legitimate claim implies that they ethically cannot be placed in the position of having to choose between these goods and their job. For example, an employee has the right to be protected against sexual harassment in the workplace. Then, an employer cannot force an employee to choose between her job and accepting harassment. The interests that are protected by rights are, in effect, exempted from the bargaining between employers and employees that establishes the condition of work. Yet, if employment at will holds sway, then no interests are protected in this way. But even within the United States, the legal doctrine of employment at will was limited from the very beginning. Over the past century, a growing consensus in both law and business practice has recognized the ethical deficiency of this doctrine. A brief review of the erosion of employment at will as a legal doctrine will set the stage for our examination of the ethical rights of employees. From the very start, employment at will applied only to private sector and non-contractual employees. Civil rights law protect employees from being fired on the basis of race and sex. For example, employees are also prevented from firing employees because of union support, health or safety complaints, or disability by the Wagner Act, and Occupational Safety and Health Act, and the Americans with Disabilities Act. Federal and state laws also protect employees who blow the whistle on a certain illegal or unethical act committed by their employer. Aside from this legislative restriction, state and federal courts have created a wide range of judicial exemption to employment at will. Many courts have recognized a public policy exemption that protects an employee's job when the dismissal would violate an important public policy. For example, some jurisdictions protect employees from being fired for serving on a jury for reporting a crime, or 3 for refusing to participate in a fraudulent business practice. Some courts have also recognized an implied contract exemption and provide employees with the protection that are implied in such employer documents as employee handbooks, job description, and job advertisement. Once hired, employees have the right to keep their job and can be fired only for good reason.
Due process in the workplace. The legal principle of due process is often traced to the Magna Carta's doctrine of per legem terrae, which established limitations of the authority of the king. So when we talk about due process, can be defined as limitations that offer protection against arbitrary uses of authority. This concept is seen in such modern legal guarantees as the right to a trial by jury legal representation, the Miranda rights to remain silent, and so forth. So, how does due process protect a public employee? So, due process rights on the job. They protects public employees from deprivations of life, liberty, or property without due process. Okay, so when we say due process in the workplace, means that your employer cannot punish you without going through proper properly set up procedures and without showing in those procedures that there is a valid reason to do so. Okay, first, due process in the workplace would mean that employees have a right to protected from the arbitrary use of managerial authority. So the employee must understand your expectations and the consequences of failing to meet your performance standards. If a write-up merely documents the performance from a problem without pointing to the consequence of failure to improve, that the write-up will lack the teeth necessary to meet due process guidelines. For second, due process would mean that while employees can be dismissed for good cause, they cannot be dismissed for no cause or even for cause morally wrong. So you've got to be consistent in your application of your own rules. Workers have the right to be consistent and predictable employer which responses when a rule is violated. In other words, problems cannot be corrected on an ad hoc basis without the employer being perceived as arbitrary or unreasonable or even discriminatory. Bear in mind as well that generally speaking, practice trumps policy. In other words, regardless of what your handbook or policy and procedures manual says, your past practices will be scrutinized for consistency. Due process right would establish the procedures or the process that an employer must go through to ensure that the dismissal is not arbitrary. So the discipline must be appropriate for the offense, occasional performance, or minor transgressions. Known as a de minimis infraction, is certainly actionable but probably not cause for termination. An employee's performance track record and prior disciplinary history must certainly be taken into account. So there are four major counter-arguments to the right of due process. First is freedom, second is fairness, third is property rights, the last is efficiency. So in freedom, due process involves an illegitimate restriction on the freedom of individuals to establish the condition of their own work. Freedom, we have the power to write, act, speak, and change as one wants without hindrance or restraint. Second is fairness, argues that if employees are free to quit their job for any reason, it is only fair that employers be free to fire employees for any reason. It is also treating people equally or in a way that is right or reasonable. And it can also mean that the beauty of something or someone. The third is property rights. Due process is an illegitimate restriction on the property rights of business owners. So here are the examples of property rights. There are many types of property rights that are each uniquely constituted by the exact items for which is described. For example, community property is owned by a group of people or a government, and rights are enforced by individuals with power. Personal property is conversely owned and controlled by a single individual. The last one is efficiency. Efficiency argues that without the fear of dismissal as motivation, the workers will likely become inefficient and unproductive. So efficiency, if that sounds like the definition of automation, you're on the right track. Additional benefits of business efficiency include higher levels of satisfaction among employees, customers, business partners, and shareholders.
Participation of rights. Philosopher John Maxwell has offered a strong defense of employee rights to participate in managerial decisions. John Maxwell argued against employee participation in company decision-making because employee participation violates the property rights of shareholders. He is in favor of exempting shareholders from having a say in company decisions. He argues that employee participation is important for respecting employees' dignity and won't reduce the productivity. John Mackle claimed or believed that employees have right to strong forms of decision-making participation. It considers objections to employee participants based on shareholders' rights, and its claim the objections are flawed. Freedom of expression, philosophically the right of free expression, especially as it applies to political opinion, has two basic ethical foundations. These are respect for freedom of expression, respect that is owed the dignity of each individual. Respect for freedom of expression. You have the right to seek, receive, and impart information and ideas of your choice without interference and regardless of frontiers. This means that we have the freedom to express yourself and to access information in this opinion of expression of others. This includes political speech, views on religion, opinions and expression that are favorably received and regarded as inoffensive, but also this may offend, shock, or disturb others, including their right to privacy. Restrictions may apply to which incite discrimination like hatred and violence. Second basic ethical foundation is respect that is owed to the dignity of each individual. Dignity and respect probably the most important values to live by on a daily basis. First impression are everything. Without respect, there is no dignity. As we've seen on television and through our day-to-day jobs or education facilities, the rich and the poor, the educated and uneducated, the youth and elderly, the boy and the girl, the soldier and civilian, etc., are endless amount of infinity separating the deficiencies. Some had literally fight and due to gain even slightest amount of respect from such a constant arranging country. Especially in today's world, the poor have it the worst. There is into very minimal respect from others. Their dignity is out of the window. In conclusion, respect and dignity go hand to hand with one another. Without respect, there is no dignity, and likewise the other way around. Free of expression. It encompasses all the different ways we use our freedom to share who we are and what we believe with the world around us. It refers to our ability to share our ideas, beliefs, thoughts, and emotions. Freedom of expression, as what the philosopher and writer named John Stuart Mill's argument for freedom of thought and discussion, for liberty, and pursuits for limits of the authority of society are often repeated in contemporary debates regarding the freedom of speech and association.
Good afternoon, everyone. I am Jerlyn Rasay, and my topic is all about the employee health and safety. So let's start with, if healthy is taken mean a state of flawless physical and psychological well-being, no one is perfectly healthy. Is safe means completely free from risk. No workplace is perfectly safe. So, employee health and safety will tend to focus on the risk faced by the workers and the level of acceptable workplace risk. From this perspective, a workplace is safe if the risks are acceptable. In ensuring occupational health and safety, it is legally required for employees to maintain a safe and healthy work environment. So you have rights and obligations as an employee when it comes to your own and your employees' health. Also, this suggests that determining an activity as safe in the sense of involving an acceptable level of risk is something that can be determined by experts rather than the actual individual involved in facing the risk. Comparing this to the risk faced in the workplace, safety experts could perform a risk assessment and determine the relative risk of work. If the workplace was less risky than the other common activities, management could conclude that they have fulfilled their responsibility to provide a healthy and safe workplace. As an employee, you should speak with your employer or immediate manager first if you have any concerns about your health and safety at work. Your initial point of contact can be your safety representatives. A trade union officer or other employee representatives might also be able to assist you. Your employer shouldn't put you in danger at work that you can't prevent. In 1970, the U.S. Congress established the Occupational Safety and Health Administration, or OSHA, and charged it with establishing workplace health and safety standards. Since that time, the major debates concerning workplace health and safety have focused on how such public standard ought to be set. The dominant question has concerned the appropriateness of using cost-benefit analysis to set health and safety standards. The field of health management, known as Occupational Health and Safety Administration, or OSHA, is primarily concerned with the welfare, health, and safety of workers while they are at work. In many parts of the world, employers are required by law to provide a safe and healthy workplace for their employees, and OSHA mandates that employers provide both treatment and emphasize the prevention of health issues. Over the previous few decades, it has significantly improved, which has eventually produced favorable results. Globally, the number of workplace accidents has drastically decreased.
Good day, everyone. My topic is all about privacy of the workplace. So, privacy of the workplace. Two general understanding of privacy can be found in the legal and philosophical literature on this topic. So, privacy is a right to be let alone within a personal zone of solitude, and privacy also as the right to control information about oneself. So, the right to be let alone with some personal zone of privacy has had the longest history within the U.S. legal system. This understanding of privacy is traced to an 1890 Harvard Law Review article by Samuel Warren and Louis Brandeis. Warren and Brandeis argued that increasing population and technological advances, example, photojournalism, was increasingly the threat to the solitude and individual citizens. Philosopher George Brinker has argued that the informational sense of privacy involved a relationship between two parties, limiting access of personal information only to those with whom one has a personal relationship as an important way to preserve one's own personal integrity and individuality. This understanding of privacy will prove helpful when we turn to the employment context and consider the relationship between employer and employees. Relationship will help determine the appropriate boundary between employers and employees, and therefore the decisions and information that ought to remain rightfully private within the workplace. We could rely on the ethical conditions for valid contracts to establish the limits of informational privacy within the workplace. In general, we can say that a valid contract must be voluntarily informed and consensual. The parties must freely enter into it. They must understand it, and they must agree to its conditions. In short, workplace privacy describes the extent to which employers monitor and collect information on the activities, communications, and private lives of workers.
So, to give you the summary of this chapter, chapter 6, it is important to note that first, work is an important and a highly valued human activity because it is necessary to achieve and acquire other central human necessities like food, clothes, and shelter. Second, take note that human rights are entitled to all individuals, and these rights cannot be bought, sold, or forcibly taken away. Therefore, both work and human rights are connected in a sense that it plays both significant role in order to allow humans live a life worth living. Nonetheless, moral rights in the workplace must be emphasized and for which every employees are entitled to in order to protect them from a certain harms that might possibly or unpredictably occur within the workplace.